Good afternoon, welcome. Hopefully we are on. If you cannot hear me or hear any of the panelists, please send us a note. Welcome to the business law section, practices, procedures, and professionalism seminar with the Middle District Orlando Division judges, Judge Lori Vaughn, Judge Grace Robson, and Judge Tiffany Dyer. My name is Anna DeVilliers, and I'm staff attorney for Lori Weatherford, Chapter 13 trustee. And in that capacity, I get the pleasure and the opportunity to appear before all three of our judges quite often. So I'm excited to be here to help them share their knowledge and preferences with all of you. Up today's CLE is 7163. And if you have any questions throughout, you can send a message and we'll try to fill it in.
All right, put it in the Q&A section because for some reason, we can't see the chat, but if you put it in Q&A, that would be.
All right. We're hearing to project a little bit more. So
all right. So sorry. So without further ado, we're going to go ahead and get started with our panel discussion. I believe Judge Vaughn is going to kick off our section on the court's preferences and requirements for Zoom appearances.
Like that. Those who know me, who've been before me, know that I have very strong opinions on Zoom, and I could take up the entire hour talking about Zoom and what I like and don't like. But I decided today I'm going to break it down into three things I want to talk about. One is the president's end to the national emergency and how that impacts our use of Zoom. Two, I'm going to talk about our procedures here in Orlando and let the other judges chime in on how they may differ from what I tell you. And then number three, my favorite topic, why I like in-person hearings as opposed to Zoom. But let's start off with this into the national emergency. And I don't know how many people know about this who don't work for the court, but we did receive a message that there's a resolution of the House and that the president intends to declare an end to the national emergency effective May 11th, 2023. So what does that mean? It means we can all come out of our house now if you haven't already, but there are specific implications for the court, most of them really for criminal proceedings and the law that allow the district court to hold criminal proceedings by video. The implications for bankruptcy court and for civil proceedings is not so much. The two concerns that we had with using video conference, Zoom, I'll just say Zoom, even though we started off with something different and terrible. We are now in Zoom. But what does it mean for the bankruptcy court? Well, really, there were two concerns. One is this requirement that our hearings be in open court, meaning that we are open to the public. Our hearings are public. But of course, if everyone's on Zoom, how do you make that work? It's not really an issue now, I think, for at least a year. All of our courts have been open. Anyone who wishes to come down and view court, the media or just members of the public can come down to any hearing and view those. So that's not really a concern. There is a concern with Rule 43 of the Federal Rules of Civil Procedure, which talks about circumstances where witnesses can not be in the courtroom, right? Rule 43 is taking testimony, which applies in bankruptcy under 9017. And it basically says at trial, witnesses have to testify in open court unless there's compelling circumstances and with appropriate safeguards. And this rule has been was cited early on in the pandemic to allow, because of COVID, to allow witnesses to testify by Zoom or some other video technology. So perhaps now with the end of the national emergency, there might not be compelling circumstances, or those compelling circumstances might be different. And I'll be happy to give you my take on that in a few minutes when we talk about procedures. The second part that it implicates is this idea of cameras in the courtroom. So as many of you know, we do not allow cameras in the courtroom in federal court. We don't videotape our hearings. We don't allow for photographs to be taken. The Judicial Conference of the United States gave us an exception to that rule so that we could allow video conferencing during the pandemic. And that's going to continue for the time being, at least. What the AO has told us is that that exception that the Judicial Conference gave us only expires 120 days after the Judicial Conference declares that the national emergency is over, and they have not done that yet. And so we don't have any indication that that's ending. The AO also told us that the Judicial Conference is considering amending those rules to allow some form of video conferencing to continue in the future, even after that 120 days after the national emergency is concluded is over. So stay tuned. What it means right now, not much is changing from what we're currently doing. So no need to worry. So what are we doing? That's a good question. In Orlando, well, actually in the Middle District of Florida, the entire Middle District of Florida, we've been back in court for at least a year now. And what does that mean? We've had in-person hearings. Anyone who wants to come down to court can come down to court. And that's the entire Middle District of Florida. My only caveat is I think Judge Colton in Tampa doesn't really have a courtroom, so she may have different procedures. So check with her. Well, let's talk specifically about Orlando. So back in May of last year, not only did we open our courts for in-person hearings, in Orlando, we actually require attorneys to appear in court in certain circumstances. So who do we require? And these are on our website. If you look at any of our pages on the Middle District of Florida website, you will see our guidelines for hearings in Orlando. Local attorneys or unrepresented individuals must attend all hearings in person. Okay. What does a local attorney mean, or someone who's not represented? That means you either live or you work within the Orlando division. Okay. So you must attend evidentiary or non-evidentiary, except judges may have some different preferences. Non-local attorneys, folks who are not within the division, they are permitted to appear by video in non-evidentiary hearings. And really, this is just an extension of the court's telephonic appearance policy that we had pre-pandemic. Okay, so that allowed out-of-town attorneys to appear by phone. The phone really is not great, and no one's ever liked it. I never liked appearing by phone as an attorney. And so we're basically saying, well, video can take the place of the phone. We still do have a phone system. We are all three using Court Solutions. You can always use that. We prefer that if you're going to use Court Solutions, it's for a listen only appearance, or maybe simply saying, we agree. We prefer for you to be on video if you're not going to be there in person. I prefer for you to be there in person. Now, what about trials and evidentiary hearings? All of our trials and evidentiary hearings are in person, whether you live here in Orlando or the area or you do not. We do not allow Zoom or telephonic appearances. But as with everything in the world, exceptions, okay? So with respect to local attorneys in non-evidentiary hearings, they can ask for permission to appear by Zoom by contacting chambers. This is all in the guidelines with an email. But if it's a trial, if it's an evidentiary hearing, then you need to file a motion to the court explaining why the person, the attorney, whether it's an attorney or a witness, cannot appear in person and request a Zoom appearance. The other point I was going to make about that real quick, and that needs to be filed at least 2 weeks before the trial. I will tell you, since we went back to trials in person, I'm not sure if I've allowed any witnesses to appear by Zoom, maybe one, and usually it's for a health reason, not simply because I live in another state.
And would they have to file a motion?
They have to file the motion and give me a compelling reason. And here's why. I mean, witnesses, the point of the trial is to find the truth. And having witnesses appear in person, I think, is important to our truth finding, activity and our ability to judge the truthfulness of a witness on the stand. There have been cases, and I'm sure people have heard about these cases where it's been discovered later on that the witness was being coached or had other information provided. I think the most famous one of that was a deposition. In fact, but those are concerns that we have, and I've heard all the different judges and courts that talk about ways to prevent that. Have two screens up, so you're looking at the screen and you're looking at him and looking at himself, and that really looks too confusing. My preference is witnesses need to be in court. The attorneys need to be in court for trials, and I think that's really important. Now, those are our guidelines. You can find that on the website. I do think, at least, and I'll talk about what I like about in-person hearings in a minute, give you my take on it. But Judge Geyer, I think you have some exceptions to that rule.
I do. I have some exceptions in Chapter 13 cases. I allow parties and their attorneys to appear at post-confirmation status conferences via Zoom. I don't have a problem with that, and that can be done without a motion. In addition, and I'll talk a little bit more about reaffirmation agreements in a few minutes, but I permit parties to appear at reaffirmation hearings on Zoom for the simple reason that I don't want to take them away from their job. I don't want them to have to, they're at a reaffirmation agreement hearing, trying to convince me they have the money to make good on the debt that they're seeking to reaffirm. And I don't want to take them out of their job to do that. So I've had people appear, certainly pro se folks have appeared on their own behalf for reaffirmation hearings. I also have Ms. Roman Secor has a client or two who are elderly and don't live close to the court, and they will drive themselves to her office because it's close to where they reside, and she will appear with them on Zoom. And so I've allowed that, and I don't have problems there. I actually, when I think back about it, of course, I've only been on the bench here for a year. I don't think I've had an evidentiary hearing on Zoom. All of mine have been in person. And it's been great. So
Zoom trials are not fun.
All of
they can
be
interesting,
right?
But not a good way.
All of my trials have been in person, but my exceptions that you won't see on the website, but word has gotten out. Certainly, post-confirmation status conferences in Chapter 13 cases and reaffirmation hearings. I don't mind doing by Zoom.
And similar, I also allow reaffirmation hearings to be by Zoom. I have allowed on one occasion a post-confirmation status conference in Chapter 13, and I am considering whether I should, allow that on a regular basis, but it's not a policy yet. I also have done both the in-person evidentiary hearing versus a Zoom or a hybrid Zoom. And I feel like it's either better if it's all on Zoom or all in person, because having the hybrid was very difficult for me, because you're looking at the screen, you're looking at the exhibits, you're looking at a witness that's on the other side too. So it makes it more difficult. And inevitably, there's always some kind of issue with the audio or video whenever someone's making a remote appearance. Want to address the question that's been posed in the chat?
I don't think that's appropriate right now.
Okay.
And with respect to the trials and hybrid hearings are difficult because you've got one person on Zoom and one person in the courtroom. They can't share papers. It sometimes happens in trial where you need to show opposing counsel, say you want to question the witness about their prior testimony, you want to impeach them, or you've got, say, in closing argument, a case that perhaps you've cited, but you want to give them a copy. You want to give the judge a copy that's highlighted. And normally my requirement is then you also give opposing counsel that. Well, it's hard to do that if they're not there in the courtroom. courtroom. So that creates difficult issues. And also with the witnesses and whether they have the correct exhibits and whether they have them in the right order and there's not someone there to help them. So there are all kinds of difficulties that you encounter. Some others that I will talk about here in a minute. Let me just tell you procedurally the way it happens in Orlando and district-wide, frankly, is we have this order prescribing procedures for video hearings that's entered in just about every case. If you see that, it doesn't mean that the court has decided this is going to be a video hearing. It's a standard order that's entered just to describe the procedures if you have permission under our guidelines or from the court to appear electronically, to appear by video. And the reason that we do that is that order gives you the link that you can use to register for Zoom. Use that link, register for Zoom. If you have difficulties registering, call the helpline for the clerk's office. Please don't call my chambers. Sometimes on like 13 days, we'll get 30 calls the morning of the hearing that they can't get on Zoom, but then the other half can get on Zoom. So it's obviously a user error. And please don't just default to calling my chambers to try and get the link because that clogs up our phone lines. And if you're calling 10 minutes before the hearing, you're not going to probably get an answer.
Right,
we're getting ready for court.
Right, our courtroom deputies are typically in the courtroom starting between at least half an hour, or even earlier to up until the hearing. And on that note, to the extent people are appearing by court solutions or you have co-counsel that appear by court solutions, the policy is to register at least 24 hours in advance, because at least with my courtroom deputy, if there are no registrations, we're not going to be logging into court solutions. Right. And so if someone logs in last minute, they may not be able to attend the hearing because they didn't register in time. So it's really to help you.
Same thing with Zoom. If we don't have any Zoom registrants, we will not open up the Zoom link. We turn it on. So make sure you register in time.
Speaking of turning it on, please have your cameras on.
Yeah.
When you appear on Zoom, you are required to have your cameras on.
Yes.
So.
And if it's say a chapter 13 day or a day when there are multiple hearings set, as soon as you log on, make sure your camera's turned off until your case is called. And so what that does is it allows us, as soon as the case is called, 5 people pop up on Zoom. We know they're here for the hearing. If we've got one person who's just been sitting there, every time a hearing's called and they don't say anything, I'm wondering if they're here for that hearing or they're here for another hearing. And pay attention to the hearings that are called. I've had cases where an attorney kept chiming in going, "Oh, is this my case?" No, pay attention
Right.
And listen for your hearing number. So your case number. Okay. Some hearings. Well, I could go on and on, but I'm going to give you, today is all about 3s. This one I might have 4. So one, I think it fosters collegiality, cooperation among the attorneys. We do these things, these bar events, because we want to talk to each other. We want to get to know each other. We want to understand how other people practice. And if we have attorneys that are going to be working with us or opposite us, it's good to have that relationship. Attorneys talk before the hearings, and they sometimes resolve things before the court comes in, or they can ask for documents or other information that perhaps they didn't get before the hearing. And I know everybody on this call, and I experienced it myself many times, of attorneys who just don't return your phone call, don't return your email. And it's not until you get them in court that you actually get an answer to your question.
They can't hide them.
Which might solve the issue that you're there on. So I appreciate that. You can easily exchange and review documents that perhaps you haven't seen before. I had the hearing the other day, one attorney in the courtroom, one on Zoom. The client showed up with a document that the client was ready to sign to solve the issue, but the person on Zoom couldn't see the document. They didn't have it. And so that made it a little bit harder. And sometimes I send lawyers out in the hallway to talk. And miraculously, it many times results in a settlement. I know if I have 2 attorneys on Zoom, I could send them into a meeting room, but I'm not taking the time to do that. yes, attorneys can talk before the hearing by telephone, but it sometimes doesn't happen. We have a small bar, and I think everybody you talk to who's probably on this call would tell you one of the things they love about doing bankruptcy is that we have a smaller bar. It's very collegial. We work together. I think coming to court is one of those things, and it encourages settlement. It also encourages respect for the court, protects its integrity. I've seen a lot of really poor practices by both attorneys and parties on Zoom. And I believe that there's an aspect of being in your home and just being on camera that causes you to not realize you are in a courtroom. Take your hats off, use correct language. I am not mama, I am your honor and judge.
That's a true story.
That is a true story. So number 3, it helps train our associates. We used to send associates to cover hearings. They could watch other lawyers. They could meet other lawyers. It's just not happening now. And 4, and this is more with witnesses and parties, it encourages truthfulness, coming through security, seeing the FBI warnings before you walk into the courtroom, seeing the judge up on the bench at a heightened level, seeing the seal behind them. There's a certain level of gravitas there that I think encourages truthfulness. So, and let me just make a last point. I'm sorry, I don't want to take over this panel. I'm not a fan.
You're doing great. You're doing great.
I'm not a fan of Zoom. I'm not a fan of hybrid hearings. I don't get a ton of Zoom requests, I think, for witnesses and trials. And I think based on Rule 43 with the compelling circumstances, I would make an argument that that there are very few compelling circumstances anymore to allow for a witness out of town. For my out of town counsel, the folks who are not in the Orlando division, yes, you may appear by Zoom. That is what our procedures say. But as they said in Spider-Man, just because you can do it doesn't mean you should do it. So think about whether you should be here in person. If you have a substantial argument that you want to make, I'd say you think you're gonna talk for more than 10 minutes, maybe you should be in front of me in court. If you think you might want to hand up some legal authority that you didn't cite in your motion, but you found the night before the hearing and it's really good, you need to bring it to court. And the easiest way is to hand it up to me while you're in court. Is your opposing counsel going to be there in person? Maybe you want to be there in person too if you're having an argument.
I've always been convinced you can get a better read on a judge when you're in person than you can over camera, especially, I mean, just this morning, my staff said, in terms of your camera positioning, would you like that closer to your face? The answer is always going to be no, or further away. And I said, further away. And I probably have tells, and I would think that someone would want to be in court so that they could see which way I may or may not be leaning. I think you're just going to be able to get a better read on the court if you're there in person than you are in Zoom. And like you were saying, if your opposing counsel is going to be there in person, I would think you'd want to.
Yeah. And the last one I'll pitch is discovery disputes. And you may disagree with me. You think, oh, these are small matters or whatever. When attorneys come together, they talk before the hearing and they realize they could be subject to sanctions. Maybe, I don't know. But it just seems like I get them to talk with each other and they realize their disputes really aren't that far off. And so that's why I'll put my plug for people coming to court.
Okay, so
Can't disagree with any of that.
all right. I think we've probably touched on some of these issues during the Zoom discussion, but are there any general trial matters that you want to discuss?
Trial procedures. Yeah, let me go over our trial procedure. I know I'm talking a lot, but trust me, they're gonna talk here in a minute, but I just happen to have the two up front. Okay, trial issues. If you're coming to do a trial in front of us, there are 2 local rules that are your best friends, and you need to understand them inside and out. Rule 7001 and Rule 9070. 7001 is a big trial rule, talks about pre-trial deadlines. It gives you all that information. And Rule 9070 talks about evidence and exchanging exhibits electronically. We do have a standard order that the clerk, if we tell them to, setting trials, which mirrors many of the deadlines in 7001. I use those for most, the run-of-the-mill matters like claim objections, that sort of thing. In other cases, I will do my own pretrial order, which I'll tell you about in a second. But one thing I want to pitch on Rule 7001 is it applies unless you have a scheduling order that says differently. I was just making sure the camera's working right. And then, oh yes, negative notice. We use a lot of negative notice in our adversary proceedings here. And in fact, there's a list of motions in 7001 that the rule actually requires you file by negative notice. And that includes summary judgment motions, which have to be filed at least 60 days before the trial. And it sets a 21-day response period there. Please don't file your summary judgment motion on the 61st day before the trial, because if you do the math in your head and you think about the 21 days, all of a sudden I have a summary judgment motion in front of me and a response 30 days before the trial. It's difficult. I have other things to do to get that ruling out in time for you to not spend a ton of time preparing if I'm going to grant it. So I would advocate for something like 90 days, but that's what our rule provides now.
I agree.
Yeah.
I found that that's been very difficult to get any
Yes.
summary judgment decided before that close to a trial date.
If we have a more complex case, I will either issue my own scheduling order, or I will encourage the parties if they seem amenable to doing their own case management order, which is something like you would see in district court, which sets a discovery deadline, sets dispositive motion deadlines, expert witnesses, that sort of thing, because our deadline in bankruptcy under 7001 is 7 days before trial. So if you don't like that, then you may want to propose to the court that the parties do their own case management order. A couple of the things that my case management order does that I like, and you can do a lot if you do this voluntarily without me telling you. Make sure you meet and confer on your exhibits. I require that. I don't think our 7001 does that. Meet and confer on exhibits so that when you come to me on the first day of trial, you tell me, Judge, we have stipulated to exhibits 1 through 10, and we have a dispute on these exhibits. I also go a little bit farther on objections in my case management order. I will put on there, if you don't file an objection 3 days before the trial as to any exhibit, that your objection is waived except as to relevancy and prejudice. That's more than what's provided in our 7001 rules. So I don't want to be surprised at the hearing, and I don't want the other party to be surprised at the hearing about objections to their exhibits. I also require you to meet and confer at least 7 days before trial on settlement. And I usually will schedule a final pretrial conference because I like to bring the parties in shortly before the trial to see what they're thinking. One thing I like that I think Judge Robson, you don't necessarily require, is binders. I know it seems kind of antiquated since you file your exhibits electronically, and that is the court's copy. So you don't have to bring a copy to go into the record. But if you have more than, say, 5 exhibits, it's going to be difficult for me to switch back and forth from exhibits online. It takes time. Sometimes our computers are slow, and I can't look at 2 exhibits at the same time. So I prefer binders. If you get a scheduling order from me, it will tell you in there what kind of binders I like. I get a little bit particular. And that you have to,
Judge Williamson binders, and we like the blue binders.
and they don't have to be blue,
Okay.
but there's a size issue. There's some that are too small. And there's too big. So I require that you bring binders to trial. There is no requirement necessarily in the rules for that, except this is what people think. Look at local rule 9070, which is on exhibits and no one really reads to the end, but it actually requires in there that if you are going to show exhibits to witnesses, that you have to bring binders. And those binders need to be for the witness, for the court, for opposing counsel. And it doesn't have to be, in my court, it needs to be all the exhibits, but for a particular witness, it doesn't have to be every exhibit. You can have exhibits 5, 10, 11, 13, because those are the exhibits you're going to use for that witness, and what we call like a throwaway exhibit binder, which you may have heard from Judge Williamson. That is actually required in our local rules. So if you plan to put on any kind of witness, make sure you come to court with your binders. And the other thing that I hate to say that I have to remind people is that in Rule 9070, it actually talks about the exhibit list and numbering your exhibits and how they should be numbered and cover letters. I had a trial with an attorney one time who filed, I think, 1,000 exhibits in the electronic portal, and then found out that I wanted binders. So I got binders with tab number 1, and that was exhibit 97. Tab number 2 was exhibit 5. No, don't do that. That is not helpful to me. So it actually tells you in there how to do it and number them sequentially. So Judge Robson, do you want to talk about your preference on binders?
I would say generally I prefer not to have binders because I actually have a method where I download the exhibits that are uploaded to, I guess, the computer, and then so I can open them. But really, if the practitioner feels like it would be easier because of the exhibit or what's in the exhibit, they're allowed, obviously permitted, to bring it to court as long as you bring a copy for the witness. If it's something that's like a blow up, where the size of it, or if it's like, because the exhibit limitations electronically, you have to shrink it down, and you want to bring something that I can actually see, then that, is understandable. But generally speaking, you don't have to bring paper exhibits for me.
And I am a fan of binders as well, but if you've got, what did you say, 5, like less than 5, then I don't need a binder. But if we're getting up to an inch of paper, I think a binder is probably a good idea. It's easier for me when I'm on the bench to listen to argument, to look at the witness, and to highlight or make notes on paper than it is for me, if I've got the exhibits electronically. So I do appreciate binders.
Yeah. And if you have a lot of exhibits, please don't bring huge, like 4-inch binders that take me.
They're unwieldy.
Yeah, that take, some conditioning before I can get to the point where I can turn the pages. I mean, it's so difficult.
I actually had a witness who had something like with her wrist, she couldn't turn the on that type of binder and needed the assistance of her counsel. So anyway.
Before we leave the subject of scheduling orders and trial practices, I want to just touch on an order that I issued recently denying a motion to extend the discovery deadline. This was one where the parties worked together to propose their own scheduling order. The court entered the scheduling order, and prior to the dispositive motion deadline, prior to the discovery deadline, the plaintiff filed a summary judgment motion. And so discovery was paused unbeknownst to the court, but there were no efforts made on the discovery front while the summary judgment issues were being briefed and under advisement with the court. Now, I think that a perfectly good reason to extend deadlines on scheduling and scheduling orders is to save your client money while the parties brief and the court considers summary judgment issues. However, in this case, I wound up denying the plaintiff's motion for summary judgment. And on the date that the parties selected for the discovery deadline, which was right after, the defendant requested an extension. Now, if the extension had been consented to, I would not likely have issued this order, but there was a dispute. And the plaintiff, who had just been denied their summary judgment, argued that there was no good cause demonstrated to extend the discovery deadlines. And so I looked at the case law, and lo and behold, the 11th Circuit says that to establish good cause, the party seeking the extension must establish that the schedule could not be met despite the party's diligence. And here it was uncontested that the movement seeking the extension had done nothing. They conceded that they had not propounded any discovery, they did not take any discovery, and so the clock is ticking and trial is drawing near, and they have not been able to demonstrate the good cause that I am required to find in order to extend the discovery deadline when such a extension is opposed. So I would say if you've got and there are some cases saying that good cause can be considered, or financial difficulties may justify an extension, but the parties have to demonstrate that they've been diligent. And there are several cases that we're finding that, where district courts have been held not to have abused their discretion in denying motions to extend discovery, where the plaintiff filed the motion to extend 1 day before the discovery deadline and hadn't propounded any discovery requests. And that's basically what I had here. So that's what I did. So that being said, and with the idea of saving your clients money, perhaps have a conversation if you've got summary judgment, that's being briefed and under advisement with the court, and just agree to toll deadlines and submit an order before the deadline, so that there is not an issue. But that's my 2 cents on diligence in the discovery period.
And our Rule 7001 actually provides that with summary judgment motions absent an order of the court, the trial will proceed as scheduled, even if your summary judgment motion is pending. So don't assume that just because you have it pending out there, everything stops.
Right.
So we're going to move on to some chapter specific topics. So we're going to start with chapter 7 and reaffirmation agreements.
Well, I just want to touch a little bit on reaffirmation agreements, and then I also wanted to mention redemption agreements with financing agreements, which seek attorney's fees. So with respect to reaffirmation agreements, when are they set for hearing? So easy one, all pro se reaffirmation agreements are set for hearing because we are required to explain the consequences of reaffirming a debt to pro se debtors, of course, their options, and assure them that this has to be voluntary. So that's easy, but we also set reaffirmation agreements where a debtor is represented by counsel, but counsel, for whatever reason, either on principle or perhaps counsel's uncertain of the math and whether the debtor is going to be able to make the payments, refuses to sign the reaffirmation agreement. So we will set reaffirmation hearings in that instance where an attorney has not signed. We will also
that's because, as if you read the rule, I am so sorry. The University of Florida, I think they're asking for money. That's usually why they call me. There's no other reason. And that's, I was just going to say, if you don't sign it, then I assume you did not represent them during the re-app process. Right. And so therefore, I put them in the category as not being represented.
Exactly. And then if the attorney checks a box of the proposed reaffirmation agreement carries a presumption of undue hardship, then we are also going to be setting it for hearing. Now, in those instances when counsel represents a debtor, but they have not represented them in the reaffirmation agreement, counsel still has to come to court. We don't want to see a debtor coming to court or appearing by Zoom by themselves without counsel, even if counsel is uncomfortable signing off on the reaffirmation agreement. We understand that you might not want to sign off on it, and that's why we're setting it for hearing. But you're not withdrawing from the case. You still represent your client, and you're still expected to be with your client at the hearing. So when does a presumption of undue hardship arise where we would set these for hearing? It's when the debtor's net monthly income is reflected on their reaffirmation paperwork is negative. And of course, if the creditor is not a credit union, because I guess math doesn't apply to credit unions. I don't understand that, but a reaffirmation agreement should be timely. It must be, and it is timely if it's filed within 60 days after the date first set for the 341 meeting. But sometimes, and I've seen this on numerous occasions, parties were not able to get a reaffirmation completed despite best efforts by that period of time. So that deadline can be extended by motion and an order. And if you're looking to extend the period of time to file a reaffirmation agreement for 60 days or less, that's done. That's not even a negative notice thing. That is something you can just upload a proposed order on, and that will be entered without a hearing. If you are requesting more than 60 days, the court may want to take a look at it and may set it for hearing, wondering why so much additional time would be needed. In addition, if a reaffirmation agreement is filed after a discharge is entered, those are going to be set for hearing because, of course, reaffirmation agreements have to be entered into prior to discharge under 524C1. But several judges, including Judge McEwen, have helped some debtors out of it who are seeking to reaffirm debts where a reaffirmation agreement did not hit the docket prior to the entry of discharge. And Judge McEwen in the Ostrowski case, that's at 635 BR 181, says that under Florida contract law, the term made, as in we're making a reaffirmation agreement or we're making an agreement, is really a meeting of the minds. And if a party can demonstrate that there was, in fact, a meeting of the minds before the discharge has been entered, then a reaffirmation agreement can be approved. But that is going to require an element of proof of intent. For example, if the debtor has filed on their statement of intentions, if they've checked the box that they intended to reaffirm a debt, that is helpful. It's helpful if you can demonstrate that there had been discussions, perhaps even before a bankruptcy case was filed and during a bankruptcy case, and that a reaffirmation went back and forth, and that the parties fully intended to get that filed before the discharge, then a reaffirmation agreement can be approved because it's going to relate back to the time when the meeting of the minds occurred, in theory, before the discharge. So when will a reaffirmation be denied? I was joking with Judge Vaughn earlier today, and I was saying that, you know, a number of years ago when I was in private practice and affirmations, I thought, well, a reaffirmation agreement should be denied where the debtor has a better car than I do. But now I notice all of the debtors have newer and better cars than I do. So I guess that means I probably need to get a new car. But what we look at is high interest rates. And speaking of which, prime rate today is, I think it's at 8%. So I have found a tendency, I'm finding that I'm approving more reaffirmation agreements for vehicles now than I did when I first came on the bench because prime rate has gone up. So an interest rate that might have seemed a little high a year ago now doesn't seem too bad in light of prime rate and what interest rate I think, you know, a debtor could get. Of course, we look at whether or not the debtor has equity in the vehicle, whether the debtor's monthly income is negative. So those are the types of things we look at. If you are looking to reaffirm a boat, I'm fairly confident that that's unlikely to be reaffirmed. Any kind of luxury item like that.
Well, what if it was
Your
a credit
house bill?
union? No, what if it's
Yeah.
a credit union and the attorney signed the thing?
No, I don't know.
Well, there's
Are they
case law.
upside down? Are they upside down in
Well,
monthly
there's no
income?
presumption.
There's
Yeah,
no
well,
presumption,
that's
but there's reality.
Well, there's no discretion either,
Yeah.
so we have no
yeah.
say. So.
I haven't had one of those.
I
fortunately.
have.
I was ready to deny, but then I
researched it. Yeah, because yeah, gut feeling would be to deny. So, and then I want to talk just a little bit about motions to redeem. I've seen a wave lately of motions to redeem solar panels. And those are done on a 21-day negative notice, and the debtor is proposing a value, and the motion's filed, 21-day negative notice. There's no objection, and I've been entering orders on those, granting those. I've also
And solar panels don't have a ton of value once they've been installed. Right?
Once they've been installed.
I had one on Windows, and they're providing proof of what a used window is worth.
Would be worth.
So creative.
It was creative. And I had not seen this until very recently, but I've seen motions to redeem where a debtor is proposing third-party financing for a vehicle. And then the financing includes fees of say $700 as part of the financing. I looked at our procedures, and there's little guidance for those types of motions, which seem which you're seeking to enter into financing. But here's my guidance. I've got one before me now, and they provided the terms of the financing, and it's a little over 21% with about an $11,000 finance charge. The payments, 56 payments, $540 a month. The total payments are, $30,000, and the amount financed is a little over $19,000. Well, that's all fine and well, but what I don't have at my fingertips in the motion is what the deal was. Like why is this a better deal? And I don't have any problem granting $700 in attorney's fees. I think redemption financing could be a good solution, but what I would like to know is how much, I don't want to have to look at the proof of claim. I don't want to have to look at the schedules. I don't want to have to pull the documents attached to the proof of claim with the financing arrangements. Tell me in the motion what the financing terms were before, and then tell me the terms of the deal and the value of the vehicle, and make it easy for me to grant the motion. So that would just be
And do it in a chart. You can do it side by side. We love that. Okay.
That would be yes, that would be great. So so I've only seen one or two of these, and I again I'm on record here saying I don't think $700 is unreasonable for motions to redeem when you're entering into a financing agreement because you've assisted the debtor in doing so. But just give me a little bit more information about what the old deal is so that I don't have to have a hearing. I can just enter an order satisfied that the new deal is a good one.
And let me just say something about reaffirmation agreements and the procedure real quick. If you file a motion to extend the time to reaffirm a debt or to delay discharge before your discharge is entered, the clerk will not enter the discharge while the court considers that, right? So that will give you time to reaffirm a debt. If your discharge has already been entered and you file to extend the time to reaffirm a debt, you need to tell me in there why your reaffirmation dates back to the pre-discharge time period. If you don't, you just file a one-page motion, which I've received many of these, to extend the time. Your discharge has been entered. You're going to get an order from me denying it because I can't approve a reaff after the discharge has been entered. So use that case. Tell me why it's dated back. I am not going to revoke your discharge just so you can get a reaffirmation agreement. And then secondly, I'm not sure what I do if you file a reaff after the discharge and you don't say anything, you just file it. I might not take any action on it and then let you and the lender come back to me later and argue whether there was a reaffirmation. If it's a pro se, then it probably gets set for hearing automatically. But if it's signed by the attorney, I don't know that it even comes to my attention at that point.
So moving on to chapter 11.
Okay, so I just wanted to add one more thing on the evidence issue. But if you're going to file amended exhibit lists or additional exhibits, You don't need to re-upload all of the exhibits you previously uploaded. And so just make sure that your exhibit list as amended is sequential and has the most recent exhibits at the end, and only upload those new exhibits. Okay, so the chapter 11 issues I wanted to bring up real quick relate mostly to subchapter 5, but some of this could pertain to regular chapters 11s as well. So my general request, I guess, of the bar would be to have more description and details that will help me understand not only about the debtor and help creditors understand about the debtor, but also support feasibility of proposed plans. And so not only, in the case management summary include, not just kind of the generic things, but really kind of what is the debtor's business about and what's your exit strategy. In your confirmation affidavit, as well as your disclosure statement, please include, a little bit of background about the case, not just a cut and paste of the plan and say that that's the disclosure statement. The disclosure statement really is intended to give creditors and the court an opportunity to understand the background of the case, why the plan is feasible. And why I say that is because a lot of times people are filing, which is great, plans timely, quickly, getting to confirmation, but that means that we haven't really had a long track record of monthly operating reports and things like that, where creditors can say, okay, well, I've seen these things, I know how the debtor's been doing. So if you could, include some of that, that would help me greatly.
On case management summaries, you mentioned that. That's one of my favorite, as a practitioner, that was one of my favorite things. You can't file an objection to a case management summary.
Oh, I got one.
It was I suppose you can file one.
It's not normal.
But yeah, but I mean, that is where you set the tone of the case. And our local rule says that you're not getting a hearing unless you've timely filed your case management summary. You've got to file that within, the first 3 days of the case, especially if you're looking for a hearing on an emergency motion. I'm sorry to interrupt.
No.
Go ahead. I love case management. I love
As a
those.
judge, I love them.
I love
they
them.
give me so
Yeah.
much more information
Yeah.
than any of your motions.
Exactly. So then on the a reminder for all the folks that we added to the negative notice list in the Middle District of Florida that applications to improve to state professionals are supposed to be filed now on negative 14 days negative notice. So that's in addition to the negative notice list. And then for, I had this issue come up in a subchapter 5 that was confirmed under section 1191B, which means non-consensual. And that means the debtors obviously don't get a discharge until they've completed all of their plan payments. So I had a debtors counsel file a motion for discharge. And I thought that was odd because I'm like, well, doesn't the final decree typically do that? But if you look at our local rule 3022-1, it addresses subchapter 5 and says, within 30 days of the later of the completion of all of the contested matters, adversary proceedings, et cetera, or the entry of discharge, the debtor will file a motion for a final decree. So it does make sense that the debtor gets a discharge and then the case is closed shortly thereafter. So looking forward to getting all the cases, discharged so that we can close them too.
Yeah, and for the Chapter 11 lawyers out there, most of our cases now are subchapter 5s here in Orlando. We get a sprinkling of regular 11s. If your plan is confirmed as crammed down 1191B, meaning you're going to be in our court for 3 years or 5 years, depending on the case. Once you reach substantial consummation, which you need to file according to our rules, a notice, we will stop generally having status conferences unless there's something pending that you need those. And we'll just sit back, kind of like we do in Chapter 13s, and wait for you to complete your plan payments and then come back to us. The case is still open. It's just no hearings are scheduled. So make sure you file that notice so we don't keep dragging you back to court just to tell us the same thing.
Right. And I think that's actually in the rule or the statute. Right?
It is
So,
that you file your substantial consummation.
Right.
Yeah.
So those are the quick things that I had about the Chapter 11.
So moving on to chapter 13.
All right. So 3 points in Chapter 13 I wanted to bring up. One is I love our district because we have this great administrative order prescribing procedures in Chapter 13. If you've never done a Chapter 13, you need to read it. This is our Bible on Chapter 13. It tells you a lot. It deals with a lot of issues that I remember 20 years ago were questionable, which is adequate protection for secured creditors. It's all in there, and it's all kind of automatic. There are issues about automatic stay, etc. So read it. So 3 things. One is motions to extend the automatic stay. Maybe you have a debtor who's filed a few times. It happens. Make sure you file those within 30 days, or a motion to impose a stay because you don't have one. Your guys filed a few times. Make sure you file those within the 30 days. It gets a little bit complicated. No need to go into the details, but if you don't file those quickly, and give me a reason in your motion. I love my consumer lawyers because they file brief documents that get to the point. But it only takes you a sentence to tell me that the debtor has a better job now, or that the debtor was in the hospital in the last case. Now they're out and they're gainfully employed. What's the substantial change in circumstances? Because that's usually what we're looking at.
Help
and remember,
us grant the motion.
yeah,
Help us grant the motion.
There's a presumption that it's the new case is not in good faith. That seems to come up in just about every motion I see, and so it puts the burden on the debtor for to provide clear and convincing evidence. So if a creditor comes in and challenges you, that's quite a burden. So make sure you do that. And Judge Gentleman always said, because they were pro se before and now they're represented, that is not a substantial change in circumstances. I tend to agree with that, but there have been unusual cases where I've still granted that. I've still allowed for the extension of the stay when it's unopposed, and if there are all the circumstances make me think that this is going to be a successful case, because that really is the key. Second issue, deadlines in the Chapter 13 admin order. There are deadlines in here. Some people forget about them. The biggest one is once the proof of claim deadline has passed, the bar date, you have 28 days as a debtor to things. Amend your plan, file your claim objections, file your motion to value, get those on file. What happens if you don't do that? Well, you're going to come to confirmation. Lori Weatherford's going to set it. You're not going to be ready because you didn't do those things. And unfortunately, we see quite a few of those. We're going to bring you back for another hearing. And then what happens after that if you still haven't done it? Well, I'm probably going to dock your fees. Lori Weatherford will ask that I dock your fees, and I take that very seriously. If you're not doing what you need to do, because a lot of these cases can run very smoothly and there's no dispute, except that the motions haven't been filed, and so we can't get to confirmation, which wastes everyone's time. So don't do that. Last one is tax returns and refunds post confirmation. In our admin order, paragraph 18 says that at each tax return that becomes due after the case is filed, you got to provide it to the trustee within 14 days, a copy of the return. And guess what? Your refunds belong to the trustee. The debtor's refunds, excuse me. So the debtor is not to spend that refund without court approval of the trustee's consent. I've seen lots of cases where the debtor gets a decent refund, and they've spent it before the attorney ever figures out that they got it. Well, if you stay on your client to get those tax returns, you're going to know they're getting a refund, and you can remind them, don't spend it unless we get the trustee's consent to do so. It's much easier to do it on the front end than to try and get permission afterwards, because a lot of these debtors don't have the money to get back once they've spent it. And let me remind you, you get $50 a month. Debtors attorneys, we give you $50 a month. That ongoing maintenance fee was designed for maybe this in particular, but definitely with this in mind, which is this continuing requirement. If everything's going smoothly, you got this continuing requirement for tax returns. And so you're getting paid, it's $600 a year. And that doesn't seem like a difficult burden to get your client to give you the return and make sure they don't spend a refund if they're getting that. So make sure you do it.
Okay, so one issue I've noticed with chapter 13s is that sometimes they convert to chapter 7. And so when they convert to chapter 7, there are documents that need to be filed as part of the chapter 7 that were never part of the chapter 13, for example, the chapter 7 means test calculation. And so we are changing the form of the order, but typically it's been the order and then attaches a notice that has the 341 date and all of that, but it also has these deadlines. And it says, one of the paragraphs was, if you don't file these documents within 14 days, your case was going to be dismissed. And I think I've had 4 cases in 1 week that all happened to, where they were converted cases, chapter 7, they didn't file the means test, and then their cases were dismissed, and all the attorneys then had to go back and file a motion to reinstate the case and file the documents. So just be aware of that potential trap, I guess.
I think that's all I had on 13s.
Okay, so we have very little bit of time. There's a question regarding refunds and what happens when they're joint with the non-filing spouse.
I think there's case law on that. I don't know if we want to give it any advisory.
Yeah, this is all procedural.
Yeah.
Yeah, there's
So
there's a lot of totality of the circumstance
Right.
situations with those. So
There's a lot that goes into it.
deal
Yeah.
with the trustee. We have forms for that. So we'll get it resolved. Okay.
A miscellaneous issue is submission of orders after a hearing. So I'm sure I'm not the only one who's had hearings, and then after the local rules provide that you're supposed to submit proposed orders within 3 days. And on some occasions, it does take longer because things are maybe more complex and things are being finalized. But generally speaking, you should all aim to have those orders submitted, because we don't want 4 months later to have a hearing, the next hearing that's set, and here's the order that came from 4 months ago, because now the issue may be moot and we may end up just denying it if it's untimely. So
I had one come up in a 7 not that long ago where we were at least a year past the hearing date and the order hadn't been entered. And I don't recall exactly how it came to my attention, but I set it for hearing. I didn't just enter the order. Maybe they submitted the order finally. And I said, why is this a year old? So I brought them into court. So if you don't want to come into court, make sure you submit your orders timely.
And I mean, I do have my staff reach out to people to remind them a week or so after the hearing, like, okay, if it hasn't been submitted, where is the order? But, that's not really sustainable.
And I think you get an automatic, don't you? You used to get an automatic ding on the pacer saying, where's your order?
Okay. I know they do that with certificates of service and things haven't been
with
served.
certificates of service and with notices of hearing. And I've seen some issue there. And just be advised, if you don't follow your notice of hearing, you don't serve it, then the hearing's not going to go forward. Cancel it. So you need to get those done. Do you want to talk about attorney's fees?
Oh, well, attorney's fees generally are by statute or by contract. So if you have a basis, that you better cite one of those, otherwise you're not getting it. That's the short answer.
Right. Well, and when it comes to fee applications, if someone's objecting to an attorney's fee application, don't just give me, overall, well, it's not reasonable, or, they spent too much time on nonsensical motions that weren't successful, Judge. Tell me what time entries you're talking about. Sometimes if it's 11, we might have hundreds of time entries. I'm not going to go and review every single one to try and figure out which one you're objecting to. Give me a highlighted list of their, of their time entries that you object to. And I'll be happy to read those and take a look at them. But give me something more than just a general objection. And then give me a suggestion of what you think is a reasonable fee if you're thinking that the fees are unreasonable. If anyone here is representing Tupperware, we're not opposed to New York rates. Come down and see us in Florida.
Right.
It's not automatically.
You practiced in New York. Yeah. We love investment bankers.
But yeah, no, I mean,
monthly fees.
that really hasn't been, hourly rates have not been an issue yet. I haven't seen it. Obviously, in our jurisdiction here in Orlando, we typically see things anywhere from $2.50 an hour to $5 something. I don't think we regularly see anything higher than that, but I haven't had anyone object to someone's hourly rate. So, but it's something that we take a look at, and we consider a lot of different factors. And good point. An attorney in your fee application, especially if you're, say, representing a 7 trustee and you're doing litigation, one of the things I jump to when I'm looking at it is the results obtained. So if you've represented the trustee and you've done this big litigation, maybe you've got a big fee, well, tell me what the result is for the creditors. Don't make me have to go and figure out and do the math. If you know as a result of your litigation, the creditors are expected now to get a 50% recovery, tell me that, or tell me that your litigation after you take out your fees resulted in a $200,000 to the estate. Tell me that. And that helps me out a lot in looking at fee applications.
Agree.
Do you have any suggestions for counsel having to deal with unrepresented parties that you have seen work in your courtroom?
I would say being kind and patient is helpful. So, for example, I did have an evidentiary hearing on valuation or a state violation issue where the debtor didn't have the capability of advance, and the counsel for the opposing counsel obviously volunteered to take the exhibits and upload them to the court using his. So I found that was extremely helpful, and obviously it didn't weigh in how I would rule, but it certainly helped the proceeding go forward.
Don't try to use gotchas for pro se litigants
Or anyone, really.
Right, but especially someone who doesn't really understand the rules. When we get to, say, we have a trial, it's not helpful. Usually with a pro se litigant, we're going to have them give us a narrative. That's going to be their direct exam of themselves. We don't make them sit on the stand and ask themselves questions. That would be weird. But we let them give us a narrative. And if you're objecting to every sentence, it really is going to make life difficult. So just be mindful that they don't understand really the rules of engagement all that well. And I'm trying to get to the facts and the merits of the case. And if you can help us do that, we'll appreciate it.
Well, if there are no further questions from the attendees.
Can we get a pitch for the pro se?
Well, I would love that. Yes, if
So there's one more thing we wanted to talk about, which was the pro se clinic. It's bankruptcyproseclinic.com.
Great name.
Where volunteer attorneys and self-represented individuals meet online for an appointment to have a consultation in about 20 to 30 minute increments. And so, like I said, so now you can meet online, you can do it based on your schedule, and we always need more volunteers. So I understand it's very easy to sign up. So I would encourage everyone that has time to please do it. And even if you don't practice in the consumer area, because most of these issues are consumer issues, you're going to know more than someone who's representing themselves. So I would say, don't be afraid.
And the judges get a list every month of who volunteers. And I always get a smile from that. What is it, Judge McEwen, who's got the column, things that make me smile, or something like that. That always makes me smile. I love seeing people's names on that list. And if you think we don't notice, we do notice. We do notice, and we appreciate we appreciate how busy you all are and the fact that you've donated your time. We know your names, we know who you are, and we appreciate you.
And if you do end up representing someone pro bono, whether it's through the Pro Se Clinic or not, if you let my court deputy know, I would certainly be happy to put you to the calendar. So bankruptcyproseclinic.com is the website.
And I think, is that where they volunteer as well?
Yes.
They go on that website.
Yeah.
And think too about if you're a Chapter 13 lawyer, and maybe we have a 13 that's ongoing, a plan that's been confirmed, and the lawyer withdraws, or the lawyer has been suspended or
passes, which happened in the case.
Yeah. We do appreciate it if lawyers are willing to pick that up and just take over the $50 a month fee just to get them through to the end of the case, because where it does become a problem usually is at the end of the case, they realize that they didn't turn over their tax refunds, or they've got an issue with a secured creditor and they need to work out whether they're up to date. That's what they usually need help with. And it is $600 a year, depending on how many years are left in the plan. So it's better than nothing.
All right, so I would like to thank the judges for always being so generous with their time and participating with the bar. We do get a CLE for this afternoon, and the CLE number is 7163. 7163. I've never seen one so short, but
That seems odd.
See if it works.
yes, that's what I was.
Letter in front of it?
There,
Okay.
that's what I was given. So,
Oh, Isabel Freeman says the link isn't
Well,
working.
Just going to sign up, you know.
Okay, well, maybe there will be a follow-up email after the program.
We'll have to look this up.
all right. Bankruptcyprostate
Okay.
clinic.com.
Are there any other questions? We still have technically a few more minutes if anyone has a question about our procedures,
Well.
what's going on in court.
Did it work?
Uh-oh.
I have to say that the bankruptcy bar in Orlando is so lucky to have you three on board. I hope they appreciate what they're dealing with. So thank y'all for doing this for them, and I'll make sure they hear it.
Yeah.
Thank you, Judge
Thank you.
Burgess.
And I see in the chat, there's a question about, could there be a listserv of, if we ever need someone to step in on a chapter 13, I might ask Lori Weatherford about that. Where it's happened before, and I'll make a pitch for coming to court, is that lawyers show up in court and they see pro se litigants there, they see pro se debtors, and they start talking. And they say, oh, I can help you out for, a small fee or just taking over that $50 a month. And I'll also make a pitch for coming to chapter 13 hearings because they all go to lunch afterwards. And
Learn
Lori,
secrets.
Lori talks about
Yeah.
she'll tell them all the good stuff they need to know to be a successful 13 attorney. It's kind of an informal discussion, right?
Yes, there's a lot of hypotheticals that get thrown around, which I think has helped out some cases go a little more smoothly. And
Right, especially if you're a younger practitioner, you get to spend some time with more experienced practitioners who've seen a lot of different issues come up over the years. And
Okay, of course.
I
Do attorneys need to appear at initial confirmation hearings? In 13, no.
now,
We have them on the calendar. If you see something set at like 9:05,
or nine.
yeah, then then that's an initial confirmation hearing, and we do not require an appearance. You'll get a notice from Lori Weatherford on the one that you need to appear at.
Spreadsheets required. They're not required. It is a local thing. Some of the attorneys will prepare one, but it's not a requirement. So I think it's
Our chapter 13 trustees office does a great job with the spreadsheets.
yes, you're not required to file them with the plan. The model plan for the middle district does say that it's optional, but if you do a spreadsheet, then your numbers are right.
that presumes the numbers are typed incorrectly.
Well, yes,
It's also-
or there's not a corrupted formula.
Only as good as the data entry.
Yeah.
Yes,
but-
but it is not, it's not required. We do prepare them as part of the confirmation process so that everybody knows exactly where every penny is going in your case.
For everyone,
Yes, thank you.
look forward to seeing you in court.
Yes. Come see us.
Thank you.